Last week, we had several important updates that happened from jury selection as well as from the judge's rulings. The most important update from last week is that the complaining witness listed as victim number 3 with the government stopped answering her phone, and her attorney stopped answering any phone calls from the government. This is a major update. However, it is not very uncommon in criminal cases. As you can imagine, people just don't want to be involved whenever the cases actually go to court. That could be for various reasons, whether that is fear of being known to the public, whether it is because they want to change their statement, or whether they've had advice from family members and friends to just not participate. Everyone doesn't always show up to court. This is a very important update for the government because it would change their strategy on how to handle their case. Last week, the government indicated during their jury selection voir dire portion that they were going to have 4 victims that would be named within this case who were supposed to testify. The reason for why they had 4 is because every witness and every complaining party of a case helps the government meet each element that is required beyond a reasonable doubt. At this particular juncture, we don't know who that victim is, and we don't know what her contribution to the case would have been. But the reports have indicated that the government was scrambling and they felt it was important enough to actually say it to the court. I view this as a win for the defense because that shows that will make the burden much harder for the government to meet beyond a reasonable doubt. The government, in fact, can force victim number 3 to come to court by using their subpoena power to force him or her to show up and testify in this case. If you do receive a subpoena in federal court, you will be required to show up, and if you do not, the government can actually ask for a writ of attachment to enforce you to show up. If they are able to get you to show up, the judge can rule to throw you in jail while you wait on your turn to testify. Even though the government has the power to force her to show up, that is not a recommendation that I would recommend. The reason why it is not recommended to actually use subpoena power with the threat of a writ of attachment is because you will create a hostile witness 9 times out of 10. A hostile witness will now be a person that will be a problem for you on direct examination because they can refuse to answer questions, they can lie to you, and they can ruin your case in a way that you were not expecting. When it comes to cases that deal with sexual assault, domestic violence, these are problems that prosecutors normally run into, and there is a certain way that you must handle these women in these particular cases. If the person does not want to show up, and if you believe they will hurt your case more so than helping, it is best to just eliminate them from your case in chief and possibly save them for the rebuttal portion of your trial. Another important update from last week is that the judge did rule to allow the defense to put on evidence that Cassie Ventura has assaulted Diddy as well throughout their relationship. This is a very important update because this same judge did rule 2 weeks ago that the government could play the video from the hotel elevator incident in their case in chief of this trial. What is good for the goose may not be good for the gander sometimes. Since the prosecution is allowed to actually show him assaulting her in a selected incident, now the defense team will be able to counteract that by showing evidence that this relationship was toxic and at times abusive, but now the abuse happened on both parts. So because that video was allowed to come in, Diddy's defense team will be allowed to present evidence that he also has been assaulted by Cassie Ventura as well. Before the jury was selected, the defense team did have a Batson challenge against the government for approximately 7 Black people that were eliminated by the government from the jury panel. A Batson challenge is a challenge that is made by the opposing party in trial by stating that the opposing party, normally the government, is striking a person from the panel because of their race, ethnicity, or sex. This law happens because historically Black people were kept off of juries in this country and not allowed to be able to participate in the judicial process against their peers. The way that the government typically combats having the Batson challenge is by stating a race-neutral reason for why a a Black person was struck from the jury. Here, in this particular case, the defense team did raise that approximately 7 Black people were stricken without a reason that was not race neutral. A lot of times this happens whenever the government does not talk to a person of color enough that is a potential jury for the case. Here, the government was able to use race neutral reasons, which would be reasons that are apart from what your creed, nationality, race is, for why they felt that you would not be a good jury for this particular case. One of the tools that the government could use to combat a Batson challenge is the questionnaires that were given out at the very beginning of the jury selection process. These jury questionnaires, as I've stated before, are questions about your thoughts and your opinions, whether that's about law enforcement, whether have you been a victim of a crime, how you have been treated by law enforcement in your own past, what you believe the criminal justice system is designed to do, whether that is rehabilitation, punishment, deterrence. All of these are very important questions to see what your thoughts are, and also to see, would you be a fair and impartial jury? And more importantly, can you follow the law? The questions that are written down and your answers on the jury questionnaire can be used by the government to see if they can strike you without having a lot of questions of you during the panel. But they do have to put on the record and make sure they ask you certain questions to justify having a race neutral response to the court. An opening statement is a brief summary of what each side intends to show the jury and what evidence should they anticipate hearing and seeing throughout the trial. It is normal for the prosecution always to go first with their opening statement, and typically the prosecution always goes first throughout a criminal trial because the government are the ones that are presenting charges and prosecuting a person for a crime. Because the government is in charge of bringing the charges and allegations against the defendant, they always have the first bite at the apple to present their case in chief first. On May 12th, the government did in fact present an opening statement to the jury. In that opening statement, they painted a picture of Sean Combs, aka Diddy, as a person that has a very dark side to him outside of the charismatic media mogul that we all know him to be. What they presented is a picture of a man that was very violent toward his girlfriend Cassie throughout their relationship, and a person that has dubbed himself as a moniker of a king, and that he has a king mentality when it comes to running his businesses, and all the people around him are there to please him in any way possible. During the opening statement, the government did give examples for what Cassie will show throughout the trial, and they talked about ways that Cassie will be able to prove their elements through the activity that happened throughout the freak-offs that she participated in, and how she was drugged and sometimes coerced into these particular acts. During opening statement, the government did present evidence of what the jury will see when it comes to the racketeering charge, which is the most important in this particular trial. The prosecutor alluded to Diddy having his bodyguards as well as chief of staff being the main people that worked with him to be able to conceal various types of crimes. A piece of evidence that the prosecution plans to show is that Diddy's bodyguards as well as chief of staff paid a hotel worker $100,000 in cash placed in a brown paper bag to conceal the video of him assaulting Cassie at the hotel. The prosecution also indicated in their opening statements that they are going to focus now on 2 victims that they originally listed rather than the 4 stated last week during their jury selection. They are going to use these 2 victims to prove all 5 of their charges in different ways. The prosecution has indicated to the jury that they plan to use these 2 victims to describe the coercion and unwanted sex acts that happened throughout the freak-offs that they participated in often. Some of the details are going to be about violence that was suffered and also the drug-fueled parties that were had that were not consensual for both of these victims. Because this is opening statement, it is not uncommon that the prosecution was vague about how many witnesses they were going to call and the lack of names being associated with these particular witnesses. Currently, the only witness that has been called out by her actual name is Cassie Ventura. Later on throughout this trial, victim number 2 will be known as Jane as a pseudonym throughout this trial because at this particular juncture, she has chosen not to have her name being made to the public. This is not uncommon in cases that are involved with sexual assault. Victims typically have a choice about whether or not they can use their real name in the indictment versus to having a pseudonym that they must be called throughout the entire phase of the trial. It is also not uncommon that the prosecution has not listed by name all of their witnesses that will be participating in the trial because they don't want to overshow their hand. As we've stated, last week, one of their main victims stopped answering the phone and her lawyer stopped contacting them about about her whereabouts. These things happen in trial as things are very dynamic and they move very fast. And so not to overplay their hand and to promise the jury something that they cannot deliver, they have opted into just having a brief summation about what the main victims will have, and they will have other witnesses to corroborate some of those pieces of evidence. The defense team also had an opening statement this morning. However, underneath the law, they did not have to present an opening today. Underneath the law, the defense team has the right to waive their opening statement and reserve for a later time, which is typically before their case in chief. Even though the government always gets to go first, the defense does have the tool, and we often do use our ability to waive our right for the opening and have in rebuttal to see what, in fact, the government will show as their evidence. Again, as the defense team, you have the advantage of going second to let the government statements come out and to let all of their evidence be shown before you show your hand to the jury. Here, the defense team also took the opportunity to present their opening early because they want to set the tone. Opening statement is all about the ability to tell a story. Whenever a jury hears this compelling story, they will follow it the entire way through the trial, and it will become their guide of what they expect to hear. The government has presented to them the evidence that they choose to show, but the defense wants to plant the seed early and have the jury look at what the prosecution is presenting with rose-colored glasses on. They want them to start early in questioning what they hear and evaluating whether or not these acts are criminal versus to just an alternative lifestyle. The defense team did take out the time in their opening statements to address both of the victims that the government has presented to be their star witnesses. In one way, they have presented Cassie as a person that had a toxic and jealous relationship with Diddy for 11 years, and that she did willfully participate in the acts that have been depicted throughout social media as well as throughout this trial, what you're going to see in regards to the freak-off parties. In regards to the second witness, they actually have addressed her as well to paint her as a person that was a jealous lover of Diddy and a girl that did participate in these freak-offs in hopes that this would further her relationship in a romantic way with Diddy. Once the money stopped and once the access stopped, this is when the victims in this particular case have become angry and now have presented this as a criminal matter, even though the only criminal act that you will see is the domestic violence that was had against Cassie. The defense also took the time out in their opening statement to get in front of some of the negative evidence that they know will come out in this trial. Obviously, the most damaging video that you will be able to see that we all have seen is the video that happened at the hotel with Cassie. The defense team has depicted this video as a isolated domestic violence incident that happened in the course of their relationship, but they also are going to prepare the jury to know that there have been incidences that have happened where Cassie has hit Diddy, that drugs and alcohol and toxicity and jealousy were surrounding this relationship the entire time. And even though these things happen, they do not want the jury to interpret that to mean that a racketeering event with his businesses took place throughout the domestic violence. Another piece of evidence that is going to be shown are the videos that were seized from Diddy's home that are classified and known as freak-off videos. They have addressed this by letting the jury know up front that these videos are going to be disturbing, they're going to be explicit and uncomfortable to watch. However, these videos were consensual for all the parties that were involved. The defense team also ended today in their opening statement by stating that everybody involved has a motive. Now, motive is not a requirement because it is not an element that the prosecution must prove in any criminal trial. However, it is still something that is always in the back of a jury's mind. People naturally want to know the why and how people find themselves in these predicaments. And here, the defense team has strategically brought this up because they have a plan to be able to show that these witnesses and victims have a motive and have reason to attack their client in this particular way, even though these relationships have expanded for over a decade. And they want people to know that money, that influence, power, and opportunity has everything to do with this trial. And when those elements stopped, that is when the victims and these witnesses decided to try to attack their client and potentially have him thrown in prison. Thank you for watching. If you have any further questions about this trial, please leave your comments below or reach out to us at versustexas.com.